Hello, fellow Toolboxers. Thank you for tuning in to episode 279 with Kevin Gregg. I recorded this a little bit back, but between just life and all that kind of stuff, this is like a 2-week late recording, but it'll get you the information you need. We're talking about federal litigation, a popular topic, a popular episode usually that gets a lot of attention. So thanks again for Kevin Gregg, host of the Immigration Review podcast, for coming on to talk about the big cases. We're here to improve your law and your practice, so that's what we're here to do. We're going to learn a lot from this episode. You can really help the podcast if you leave a positive 5-star review, like, subscribe, all that kind of stuff in iTunes, wherever you're watching this. It helps the algorithm promote our stuff more so other immigration lawyers can learn about it, because there's a lot of stuff we're doing. For example, we just recorded a live CLE, our first live one, for learning about U.S. immigration for Iranian cases. We had a large group there. It's really good. The recording is available on our community page on circle.so. If you're not a member already and you're an immigration lawyer, email me and I'll add you. We may be doing stuff for paralegals. We have a lot of paralegals to listen to. Just email me so I have your email in the system once we open up stuff for them. But if you're an immigration lawyer, join the Circle community. We ask discussion questions. We have samples of my FOIAs and stuff like that you could use, and more CLEs recordings we're going to have there. That's going to be really helpful for your business. And the sponsor for the CLE, as well as sponsor for the podcast, a great company. A lot of you are already members and subscribers, is Cerenade's eIMMIGRATION. Cerenade is all-in-one forms program, winner of a lot of reviews about best service, best experience, a lot of good stuff. And they're really kind. They give a special program to give a discount for Toolbox viewers. All you just got to use is, use the offer code Immigration Lawyers Toolbox Offer 2023. You get $400 off the site setup fee, $600 savings off conversion fee from their standard import, and a free month, which would be multiple months if your team is like 5 or 6 people or one person. The more, the merrier. So definitely check them out. Contact them at sales@cerenade.com, and Cerenade's with a C, and or just go to cerenade.com/immigration. And Cerenade again with a C, and do a test run either with them or on your own. See what the software is. Obviously, it's been in the top one for a long time. It's been the game and a big competitor. So something to worth view. And they've been a big supporter of the immigration space for continuing education. So I really appreciate them for all they did. Having said that, if you're interested in more information, just email me at info@immigrationlawyerstoolbox.com. And see what we can do. If you have an idea, you want to write an article about something or the like, just let me know. Without further ado, let's get the show about general education started, not intended for individual legal guidance. So Kevin, thanks again for coming on the show. A regular coming up for the February 2022. Obviously, everyone knows Kevin is Immigration Review. Challenging, battling it out with Immigration Lawyers Toolbox for the top podcast in the iTunes scene, which I love it. If there's going to be a battle, it should be between us because we come on each other's show. So it's beneficial for both of us. But thank you. How's it going? How's life?
There's no battle at all. Life is good. Life is fun. Life is busy. I think that's probably sums up every single immigration attorney.
Yeah, for your life. Yeah. It's always something. It's like I have some lawyers, we're prepping for the AILA conference things, and I have like the CLE I'm doing, and it's just like trying to get some time to match just to talk and prep for a panel or something like that. It is just so difficult because we're so slammed with work in one way or another.
Did you do your O conference, by the way?
Yeah, it was really fun. It was 11 out of 10. I was like, wow, this really went down really well. Everyone was loving it. The big work now is editing the video to make it into like really neat and stuff, and that's on my to-do list. But it was a lot of fun. People from all across the country came. I'm like, okay, for sure, we're gonna do another one of these and make it a regular thing because it was such a success.
That's awesome. Congrats.
Thank you. And I want to do other areas of law too. So especially with your specialties in your local, we can always do a thing in San Diego. You come and get local practitioners that have expertise and just jump around city to city and do these fun in-person workshops to really get into it.
Yeah, it's really cool. Glad it went well.
Thank you. So let's jump into the first case, which is an interesting case that practitioners need to know about.
Well, as always, I've got 3 cases for you. This time, not as always. Sometimes it's 2, sometimes it's 1, sometimes it's 3. But they are definitely going to be non-citizen friendly. And the first one I want to talk about is the matter of Duarte-Gonzales. Not always that we start out with the BIA, but the BIA issued a non-citizen friendly decision, so I've got to give them some love. This is the one about the unlawful presence bar, 212A9B, the 10-year bar or 3-year bar, I suppose, for that matter, for just unlawful presence that's triggered when you leave the United States. But it's very important that this is not 212A9C, that of course you know about, that other people need to recognize. This
Very
is not
important.
the
Yeah.
permanent bar. This is not, when you've left after accruing unlawful presence or after a final order of removal and then entered the United States illegally. That is 212A9C. That's the permanent bar that requires 10 years outside the U.S. before you even can waive it, file a waiver. But 212A9B is just the one that we always file I-601A waivers for. And in Duarte-Gonzales, the BIA said that the 10 years can run while the non-citizen is inside the United States. They don't have to wait 10 years outside the U.S. And actually, the BIA relied on 212A9C to reach that holding, because the BIA said, look, 212A9C is right next door. That says you got to wait outside. 212A9B does not say that, so you don't have to.
Yeah, it's interesting they did this. As you know, like USCIS already made this decision a little while back. And so when it popped up, I started getting messages about this. It's still going to be a small group of people who are affected by this, who have the opportunity, have done this, back and forth. So essentially, it's if someone somehow got a waiver and re-entered, or somehow had a tourist visa that was still valid, and they didn't pay attention, they got back in.
Yeah.
They go run the clock that way.
Yeah, I think that's essentially it. Someone has a tourist visa, and they somehow get back in legally without a misrepresentation just because they mess up at the border. I think it is probably a small group of people, because you have to enter lawfully that second time when essentially you weren't supposed to be let in at all. And it almost becomes dangerous too, because if I'm a USCIS adjudicator, or an immigration judge or a trial attorney, and I'm trying to be adversarial, I think there are immediate issues of, well, how did this person come in with their visa?
Yeah.
Did they make a fraud at the border? And if so, then we're not talking about 212A9B, we're talking about 212A6CI, and you've got big problems there. So, it's a good thing. Hopefully it doesn't lead to an increase in fraud finding. Also, don't want to be the one who's out here telling ways to get at non-citizens. But
Yeah,
it's cool. It's a good decision, and it's good to have it.
Yeah, a lot of times it's the waiver that they're coming in. It's always arguable. Like, yeah, if you have a facially valid visa, I actually have had it where people, especially for the border crossing card from Mexico, where if for various reasons they overstayed, it should be invalidated because they overstayed, or they go outside like the definite area, it doesn't automatically get invalidated. But CP doesn't pay attention necessarily to this stuff, so it's easy enough. But yeah, they always come back and say, I think they have weaker grounds to stand on when it comes to that. And then, visa waiver people might sometimes just get in. I had this guy come to us, and he had a bunch of criminal history, and he just didn't mention the visa waiver. He's from a European country, and he just came in multiple times, and then eventually wanted to adjust status. And I'm like, well, tell me about your history. And he's like, been in prison and stuff. I'm like, how do they not catch that? You're from like a country that shares all the information with the U.S. You come multiple times. CBP knows if you scratch your nose. How do they not know that you're in prison for like 5 years? So like, it's kind of nuts how this stuff works out. But if he was able to get in, obviously prison stuff's going to be a major issue for adjusting or something. But if he got in, then he got in.
As will the visa waiver stuff. That's a whole nother bag of worms. The rights of visa waiver violators. But what I said on my podcast too is the matter of Quilantan issue. What if a non-citizen is waved through at the border, which happens, right? And if it's a procedurally lawful admission or inspection, whatever you call it, does that count? Seems like it should. And so then you'd have the situation where you have someone who's maybe, been here for over a year unlawfully, left, and come back in, and they allege and they have proof of the wave through. Not only are they not subject to 212A9C because they didn't enter without inspection and admission, and that would be, you'd really have to prove that, but the 10 years could be running the whole time if matter of Quilantan is read in conjunction, and all the precedent afterwards, if it's read in conjunction with this new case, matter of Duarte-Gonzales. So, as always, new decisions lead to new arguments and new issues, and I think that's one that's out there.
I've always, people have had success with the Quilantan case. When the situation came up for my case, usually it was DACA people who had advanced parole travel ability, so we just used that. We didn't have to go. But I always thought if the DACA person didn't have it, I probably would do a Quilantan case. It hasn't come up in my office because, you still have prosecutor discretion or whatever. They're not going to pursue you for it. So it's worth a shot to give it if it doesn't work. But I'll be hesitant to tell people to use it if they don't have other kind of status because they go to removal afterwards. But it'd be a great thing to test out. But I've just been hesitant to use Quilantan because it could open up a can of worms potentially by just taking yourself in that interview. What kind of stuff have you seen in your practice or with colleagues on that case with regard to
Oh,
Quilantan? Yeah.
oh yeah, I mean, no, it's definitely a risk. Like if you don't, if you're just going to affirmatively be applying for something and that's your only option, you better come in with a whole bunch of evidence to prove that,
Yeah.
which is going to be very difficult to do. But if you're already in immigration court, so cat's out of the
Oh, yeah.
bag.
Exactly.
It's an interesting issue because I'm just trying to think about it. It would be DHS's initial burden, not your burden, but DHS's initial burden to establish that the non-citizen is properly charged. And the three check boxes on the top of an NTA, either applicant for admission, EWI, or inspected and admitted but removable.
Yeah.
And so at a Quilantan maybe would have to be that third checkbox, and obviously DHS would be probably checking the second one, alleging
Yeah.
that the person is EWI, that they actually entered without inspection. And so it would be DHS's burden to prove the sustainability of that. So if you're in immigration court, then of course you put your client on the stand. DHS has a burden by clear and convincing evidence. Then you've actually got a thing. Now, of course, it's the non-citizen's burden to establish eligibility for relief. I just really enjoy this playing out in my mind
Yeah.
because DHS could then pivot and allege that the individual was inspected and admitted but is removable. But if they
Mhm.
do that, then your client would become eligible for adjustment in this scenario where they're
Yeah.
married to a immediate relative. So I don't know, it's an interesting issue. I hope to get that one day.
Hope so too. It'll be an interesting case, and case winning here. I wanted to jump in for a quick second and talk about one of our wonderful new sponsors, ImmigrationEvaluationDirectory.com. Did you know research reports psychological evaluations can increase an asylum applicant's chance of approval by 78%? Psychological evaluations are hugely beneficial in hardship, cancellation, asylum, and other types of immigration cases, whether with USCIS or the Immigration Court. Connecting with qualified clinicians has never been easier thanks to the ImmigrationEvaluationDirectory.com. Free to use, you can filter the directory by location, language, case type, and more, then review profiles and reach out. The Immigration Evaluation Directory is your one-stop resource to find the best therapist to help. Explore more today at immigrationevaluationdirectory.com and get the help that you need. Well, real cool. So it's a really good case. Practitioners got to know about it. I mean, USCIS always already made a policy, but I guess it was BIA decision, right? So BIA is official. And, it pops up in my practice 10 years plus. Like I've had probably 2 or 3 cases where this would have played into it. Because before I would base it on if someone had the waiver, they came in with a 212 waiver or whatever that Haranka waiver is. And so we had like situations where we could. But at the time, this is like, I remember last one was like 3 or 4 years ago. It was one of those case by case, office by office discretionary stuff with USCIS, whether they would accept a 10-year running in the United States or not. And so I was like, well, I knew some offices specifically that did accept it. I'm like, well, if you could get your jurisdiction in this office, then it would, but I don't know about these other places, what they're going to do. So the people are just were like stuck, like not sure which way to go. But this is great. We have it on record that this is the way to go.
Yeah, I mean, I mean, I'm prejudiced, I'm biased because I started my career with UIR, but like, BIA binds USCIS, but USCIS doesn't bind BIA.
Yeah.
BIA is this, it's the Supreme Court of Immigration. So like,
Yeah.
you'd always rather have BIA, and I
Exactly.
don't know the deference that a circuit must do to a USCIS policy memo is nil, but the deference to a BIA decision is high. So I always would rather have.
As you always say, it's the other circuit or something like that, right? You say it's the 10th, whatever, 10th circuit or something. We don't
That's
always
right.
say it, but I've heard you say something like that. All right. So, I mean, quickly for listeners as well, the internet and stuff is kind of cutting it out. And, I made a double recording, so at least we get the audio in it. The video is cutting out. But I hear you on my side. But what's the next case that we have, Kevin? What's going on?
Yeah, no, I hope the internet's it's good. I hope the audio at least. People don't need to see our faces anyway. But the next case is Serra v. U.S. Attorney General out of the 11th Circuit. These are the
Mhm.
February cases. I can't not talk about this case when the 11th Circuit issues a decision favorable to asylum seekers. It doesn't happen that often. In the 11th Circuit, it doesn't happen that often anywhere, but it doesn't happen that it happens like 2 times a year in the 11th. So it's a good one. It starts off with the 11th Circuit saying essentially that Cuba has been persecuting political dissidents for 60 years, which is just a great quote for all Cuban asylum cases. And not just asylum cases. I mean, any Cuban case, really, where hardship is an issue. We get we get bogged down with these cases thinking that they're asylum, but like all the evidence in an asylum case is good for a hardship case too. When the 11th Circuit has said how bad it is for people in Cuba, that's relevant for a lot of reasons.
Yeah.
But Mr. Serra was a Cuban dissident. He was labeled I think he was labeled a worm, is what they said. They called him a gusano, which is it was apparently a Castro word for like counter-revolutionaries
Oh,
or
I see.
something like that. But he gets beaten, he gets imprisoned. The standard stuff from a legitimate case. And to summarize it, the 11th Circuit believed that the immigration judge was impermissibly focusing on the incidences, and knocking them down individually rather than considering it in totality. But also, like, he was beaten so bad that he forced out a kidney stone. So that's a pretty bad beating. But it's even better for adverse credibility. And here, the 11th Circuit is really there's only a handful of cases in the 11th, and I'm a partner at a firm that's based in the 11th, even though I'm in San Diego. So I always keep track of the 11th Circuit decisions, like all decisions. But I know the cases for adverse credibility in the 11th. There's like 3 or 4 that you're always going to rely upon, and now this is one, too. The 11th is saying that there are certain inconsistencies that just don't matter for an adverse credibility. The fact that Mr. Serra said he estimated that he traveled through 12 rather than 11 countries is just
Yeah.
doesn't matter. The fact that he said that, that it seems like the kidney stone came out immediately when then he testified that it came out a week later. And when you're relying on the initial transcript that you have with, border officials, which isn't even a transcript, really
Yeah.
explaining and adopting a lot of these standard ways to attack an adverse credibility
Yeah.
finding. And I especially like out of the 11th this quote, and this is about the countries that Mr. Serra passed through. And the 11th says, quote, given that the standard the Adjei used to measure his credibility was of approximation, the substantial evidence compels reversal. End quote. But to restate that, if Mr. Serra or your client is in court saying, I believe it was about 11 countries. If I recall, it was about 12 countries. If I recall, the kidney stone came out a couple of days later. If your client is in there doing his best, but is not, being completely identifying completely the fact, I think you're in a better place. I
Mhm.
tell my clients when we're talking about dates and stuff, like, unless they are positive, unless they know, right, your son was born on May 5th, 1985. Fair enough. But otherwise, if you're talking about dates, month and year are okay.
Yeah.
I think it's rare that you're going to get an adverse credibility where it's based on the fact that the individual testified about month and year, or, said, I believe that it was about a dozen countries. But if you say it was 12 countries, and then later you say, I believe it was 11 countries, well, then, people jump and they say there's an inconsistency. But here's the 11th saying, if you're approximating the whole time, that's not an inconsistency. That's just somebody doing their best. And that's not inconsistent. That's not adverse credibility. And so I think that goes to prepping your clients in a certain way, which is quite frankly what people do all the time when preparing clients for depositions or federal court testimony. You never want to give the other side a way to really pin down a
Yeah.
potential inconsistency because people make mistakes. There's no reason to be specific unless you're positive. Or
You know,
rarely is there a reason.
I've had cases at USCIS where they do the interview, but they separate them, and people are like really honest mistakes that any couple in the world makes about like, estimates of what time we went to dinner last night or something like that. And then they'll get denials and they'll come to me with it. And I'm like reading it. I'm like, really, you really spent the time to write it out based on this. Like, it's unbelievable. But some of these officers are out of control when it comes to this stuff.
Right. I mean, it's like it's like if the question, what is your spouse's favorite meal? The answer is a steak, not a medium rare steak. Like
Yeah,
adding the extra specific stuff only provides grounds for adverse credibility, for
yeah,
inconsistency. That's what people do. That's what bad cross examiners do, is they try to get immaterial inconsistencies and make a mound. What is it? Make a mountain from a molehill, to
exactly.
flip around the phrase.
I do need to make a correction. I said, the BI is like the 10th circuit, and you mentioned Florida's the 11th circuit. I forgot how many circuits we have. I thought ninth was the last one for either.
Oh,
So,
no, no, yeah, you actually, so you broke up during that part. No, I guess the BIA would be the 12th circuit,
12th
if
circuit.
you're
There
not
we go.
including the DC circuit, maybe the 13th circuit.
13th. Okay. Okay. So,
But it's still below everybody. I'm not going to raise the BIA up to the level of circuit.
fair enough. I wanted to mention this study that came out that we didn't plan on talking about this, but is there another case, or kind of mentioned that one?
Well, let's talk about the study. I mean, there's another case, but we do whatever we want. It's your
Yeah,
show.
the study, and we both have we have other podcasts we got to do in a few minutes and 20 minutes, but that came out where it said if you are going to federal litigation, appeals, immigration space, if you are going with a big law firm that's doing like a pro bono, a small law firm, the chances of success are like extraordinarily higher if you have a big firm handling it as opposed to a small firm, which obviously could be very offensive to the mass majority of immigration law firms that are considered small law firms. And so, have you heard about that? I just read some AILA commentary in the listserv. I didn't get too much into it, but have you heard of this study or these comments?
I'm sorry, I got to ask you to repeat it just a bit. Was it that if you're in a big firm, you have a better chance of winning in federal litigation than if you're in a small firm?
Yeah, they did they say significantly better if you have the resources of a big firm. The chance of success is much like extraordinarily greater than if you get like an immigration law firm.
And this is in federal court, not immigration court?
Federal appeals court. One of the arguments was that these big law firms have more federal experience than smaller firms, so they can handle it. Plus, they have the staffing to be able to handle like the amount of paperwork and all that stuff that's involved.
Yeah, that's not surprising at all. I think I have seen this. I mean, when we brought our TPS litigation against the Trump administration, um, for ending TPS for Haitians after Trump said all Haitians have AIDS and why do we need more Haitians and blah, 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 blah. We brought that with Mayor Brown, the big law firm. We did it for a reason. I mean, the amount of manpower, the amount of the discovery was something like 65,000 pages, and we had like 6 weeks of discovery during Christmas in 2019 or something like that. Like it would have been impossible for our firm to do it. Not to mention, and it's public. I won't get into the numbers specifically, but that litigation cost
Oh,
millions of dollars, and that was before it even got appealed to the Second Circuit. A small firm can't afford millions of dollars. I mean, for the trial alone in the Eastern District of New York, Mayor Brown graciously rented out half of the floor of a hotel in Brooklyn. So and they brought in printers, and I mean they had a whole war room. So that's what's required of federal court. I think it's kind of tragic, and it's an extension of this, the fact that immigration practitioners don't really do their own Supreme Court litigation anymore.
yeah,
And we, worked with Wilmer Hale on the Patel litigation, for example, before the Supreme Court, because so much goes into it that if you don't have the resources, it could really bankrupt you. I mean, again, public knowledge. I think Mayor Brown had a gross profit last year of $1 billion.
yeah.
So it's just different worlds. So it's not surprising if you're throwing 5 or 6 really smart people at something, it's going to have a better result than one,
Yeah,
which
and
is
there's
too bad.
there's an aspect that they'll be more picky on the cases they do,
That
whereas
too.
smaller firms might just a lot of stuff's Hail Mary kind of stuff we're throwing out there. I mean, they're not going to just pick any case like, okay, this one they have probably a board that analyzes these cases, makes decisions on things that are worth the shot, worth the time. So, but yeah, it's an interesting phenomenon, and it is what it is. Yeah, it's just how it goes.
Yeah, that's how the world goes.
Totally.
The
What's our
the
third
last
case?
case that I had before we go, and
Yeah.
I wish we weren't having such audio issues, but I look forward to you editing it on the
Let's
back
see.
end, is the
Hopefully,
Adjei v. Mayorkas case out of the fourth, which is just
Mhm.
so cool. And, without getting, it's about Ghanaian marriage. And essentially, you know, the individual was getting his green card through his wife, but his wife had been married to a Ghanaian individual previously. They're all from Ghana.
Yeah.
And the allegation was that they didn't divorce properly the first time, hence the second marriage is not legitimate. And the second marriage violated Virginia law. Like, Virginia
Mhm.
law essentially requires that two divorced couples that at least one of them be in the jurisdiction of divorce, apparently.
Yeah.
And neither of the divorcees were in Ghana at the time. But the Fourth Circuit said no, the bigger law in Virginia is to recognize valid marriages and to give comity to foreign nations and to states, and that marriage is cherished and to defer to it at any time. So it's an interesting case. It's a great win for
Yeah.
for the petitioner, for the petitioner in that case. But it's an interesting case to show that, foreign law can trump USCIS and state law even, and never give up, because this seems like quite the fight before USCIS, and then on appeal, and then in district court, and then lo and behold, the Fourth Circuit says no. You got to listen. If it's legit in Ghana, it's fine for Virginia.
You
So
know, this case is close to home because we had the same fact pattern in December come to our office, and I said in California they've said this is going to be an issue and they won't accept it. If you have like a previous marriage, you got divorced outside and you're not subject to jurisdiction of California, blah blah blah, because they want to do it. So we told the client, hey, we get a marriage attorney to sign off on this, and they couldn't get a marriage attorney that was. They'll email us. We had a marriage attorney call us and say, "Yeah, it's okay." I'm like, "Okay, put that in writing." So, because I'm a California lawyer, I can't talk about Virginia law, about state law when it comes to marriage. And they were unwilling, like they're all unwilling to put it in writing. I'm like, "What kind of nonsense is this?" They call me and tell me what to put in writing. So I said, "I can't handle your case. We submit this, to be a problem." 2 months later, the decision comes, which actually goes. I did the right way, because if it came all the way to go on appeal, that means it was a serious issue in Virginia. We're going to deny it. They would have based it like how they're doing it, but. This was a really big helpful for that client. Now they are rest assured their case is going to be approved, at least on this aspect of it.
yeah, I'll say this though from the story. Like, anytime any attorney isn't willing to put it in writing, that the red flags start going off,
Yeah.
right? It's like, why don't you want to put it in writing? Like, I need it. If it's not in writing, it doesn't mean anything. But
The client would get frustrated. Like, did you talk to the lawyer? I'm like, yeah. Why would they just call me? Just put an email. Plus, like, they would just call me randomly, and I was like, I can't discuss to have a client. I can't confirm or deny that this guy's my client or a consultant. I'm not allowed to. It was so unprofessional, and like I was like, what's going on with these? It's probably getting like these cheap family lawyers or something like that. But it was like kind of just a weird scenario. But I had to turn the case down. But this case really solves the issue that we had.
yeah.
Well, good stuff, man. We have a couple minutes before we leave. What's the plan? I mean, it's March right now, whatever February case is. How much traveling you got this month?
Well, I just got back from Miami, and it's looking like I'm going to be in Miami at the end of the month as well. They graciously invited me to speak at the FBA conference in DC in May, so it looks like I'll be heading out to DC, and I don't know. I like it. I like to travel. Don't have kids yet. We'll see what happens.
Yeah, when the kids come, it's harder. But like the FBA,
Much
that's the
harder.
Federal
Do it
Bar,
now.
yeah, Federal Bar Association. You went there last year too, right?
I did, yeah. No, it's a cool conference, and I'm excited that it's going to be in DC as well, because then there'll definitely be a lot of, uh, federal government employees, because we're in their backyard, and it's like the only conference a lot of federal government employees are allowed to go to, so they go to
Yeah.
it.
I think AILA is having some sort of conference too, because I was looking at it, and they're having like it's like a lot of government kind of stuff going on. DC chapter is doing it there. But it's interesting because it seems like the FBA is like immigration is taking over, because that's like the hottest growing. Because it's FBA is for all sorts of different federal litigation, but it seems like immigration bar the last 5 years has really taken over because of how much need we have for it. Thank you everyone for joining us today. Catch Immigration Review, the best podcast in the game when it comes to litigation kind of stuff. Because I'll carve out the best podcast for other stuff for myself, but hand in hand, we're helping you out to become the best immigration attorneys you can. Tune in next time, and hopefully this recording comes out right. You guys can actually hear this. Until next one, have a good one.